Mr. Wilder.
Good morning, Judge.
Good morning, Mr. Wilder.
Good morning, Judge. Can you hear me?
I can hear you. I cannot see you. I can hear you.
Okay. Well, I don't know what happened to the video. Let me see. Start video.
Mr. Hughey, you flashed on.
Yeah.
There's Mr.
Yeah.
Robinson.
Yeah. Okay.
Try it again, Your Honor.
There you are, Mr. Hughey.
Okay.
Good morning, everybody.
Good morning, Your Honor.
Good morning.
I think we must be waiting on Judge Dean's iPhone. It says Chad's iPhone. I guess that's Judge Dean. Yes. All right. I'm gonna go ahead. Judge Dean is a party, but I don't think he's necessary to the matter. I don't know if he can get connected or not. All right, I'll go ahead with these matters. This is cause number 22-298 Flowers et al. Versus Freeney et al. Got two matters before the court. The motion to reconsider and the motion for court to approve broker and receiver's report of sale. And I'll note that this is being broadcast, our hearing being held by Zoom and broadcast over YouTube in order to comply with the open courts doctrine. And if you will note that Mr. Hughey, Mr. Robertson, and Mr. Wilder are all present, and Mr. Gage also. All right, you may.
Judge,
Yes.
this is Judge Dean down here.
Yes.
I'm sorry, I just got in trying to figure this phone out.
All right, we're just fixing to get started.
Okay.
Mr. Hughey, you may proceed on your motion to reconsider.
Yes, Your Honor. First of all, this motion to reconsider, Your Honor, and I guess it kind of conflicts with the second matter that you say is on the docket, but be it as it may, I filed a motion for the court to reconsider its order to sell all the land that's currently in question before the court. And following this motion, it's under the Uniform Petitioning of Heirs Property, which is a statute that's fairly new, as 2017, but not a whole lot of case law on it. But if the court recall that in the last proceeding, we argued the fact that my clients, the Freeneys, there are four of them, that they wanted to have their particular property basically petitioned in kind, but actually as a unit, the four family members. And when I filed this motion, I raised an argument that's on the last page of my motion that deals with the legislative history of this particular statute, and in particular, a portion of the history that was presented by the senator that was presenting this particular bill and everything. And it contains a section that basically says that co-tenants to buy out others if they are not the ones who requested petitions, and set out factors to be considered by the court in determining whether to order petitioning in kind of some or all the property. And I want to park on some of all the property, because we all know that in interpretation of a statute, sometimes we have to go back to literally to the bill itself. And what I'm tending to the court today, that this language the court has determined whether the order petitioned in kind or of some or all the property actually leaves in the position that what we were asking for was not an oddity. This particular statute, basically, when you started looking at it, because it's dealing with co-tenants, was dealing with issues that one basically runs into when you're dealing with co-tenants, as to some want to sell and some don't. And what I'm tending to the court is that this language as to the petition in kind of some of all basically leaves in the position that what we were asking was not a board or off board. And as I indicated in the motion, we're not asking for our sliver of property to be in the middle of the property as a donut. Actually, what we're saying is there are reasonable parties in this case, and to carve out what we were asking for wouldn't jeopardize the sale of the property. We're talking about 94 plus acres, and we're talking about trying to carve out a 0.00775 for my clients. So we're tendering to the court, and this reconsideration is that we should be afforded the opportunity for them to maintain that piece of property. Now, I think the court made reference to the court approving the order of sale. Well, I filed this motion timely, and it was on notice to all parties. And the only reason that we're basically entertaining it at this late date and time is because the Flowers parties, and I sent that to the court, your court coordinator when we were asking for additional dates. They wanted something after October the 4th because they were going to be out of pocket and everything. And, it's kind of like say, oh, okay, that's what you want and everything. So I guess I'm asking the question that if the property, it's my understanding that the property has been sold, I have a question whether or not it procedurally could have been done during the pending of this motion that had not been heard. So on that note, I tended two arguments to the court. First of all, we're still asking for our sliver of land to be carved out of this 94 acres. And like I say, I think there are reasonable individuals before this court that we can find something to carve it out. And obviously we'll pay for the survey to cut our slice out. But this statute, I think, was designed to deal with these kind of issues and everything. So I'm asking the court to allow my clients, to have their portion of this property that's been in their family's lineage, I think since at least at a minimum since 1938. And so that's my argument that I'm tendering to the court, and what I'm requesting on this date that we be afforded the opportunity to carve out an in-kind disposition of our property interest to my four clients, Mr. Ernie Freeney, Dorothy Freeney, Ananias Freeney, and James Paul Freeney, Your Honor.
All right. Mr. Robertson?
Yes, Your Honor. Your Honor, we had a live hearing in the court on July 15th. And we discussed some of these issues and the feasibility of partitioning in kind versus partition by sale. And after a good bit of discussion and argument, the court made the decision that the most reasonable thing in this instance was a partition by sale. And also the simplest and easiest procedure was partition by sale. We talked about, the need for surveyors, commissioners, if it was partitioned in kind. We also talked about the fact that different portions of the property have different values, and it would be difficult to determine which portion, if it was partitioned in kind, which portion of the property would be partitioned in kind. And the court made the finding in its order, which was entered on July the 25th, that a fair and equitable division of the property could not be made. A partition in kind would apportion the property in such a way that the aggregate fair market value of parcels would be materially less than the value if sold as a whole. So the court appointed Mr. Eric Gage, who's highly qualified as a broker, to sell the property and to act as receiver. And he has done an excellent job because he has found a buyer, and he's here to testify. I think I don't see his picture on the screen, but
Yeah.
I think his and I'll offer him in just a minute to confirm this, but I think he has found a buyer, and this property is not easily marketable because of the access. There are no utilities. The access is problematic, but he has obtained a buyer who is offering more per acre than what Mr. Gage originally thought would be possible, and about $17,400 more than the minimum sales price found by the court, and ordered that the property not be sold for less than that. That being the case, I'd like to offer Mr. Eric Gage to testify.
Well, let me hear from everybody else first, and
Okay.
Okay. All right, Mr. Wilder.
Your Honor, as ad litem in the case, and at the hearing that Mr. Robertson references back in the summer, I made my announcement that as far as the unknown heirs were concerned, I feel like they were properly joined and they've been properly presented to the court at this time, which is certainly my responsibility. And I don't see that they've been damaged or harmed by anything up to this point in time. I don't know what their wishes would be with regard to sale in kind, or but I must say, maybe it's just the old lawyer coming out in me, but I am persuaded and would ask the court to consider at least, or reconsider, Mr. Hughey's position. I didn't feel like at the time of our July hearing that there had been evidence to establish that the small partition in kind could not have been accomplished. I didn't think there was evidence to suggest that it had been attempted. And if so, that it would have destroyed the ability to sell the rest of the property. I was persuaded a bit that maybe both of these interests could be accomplished, and maybe Mr. Gage can weigh in on that today since he's here and maybe can give us some testimony on that. But as far as my role with the court, Your Honor, I would stand on that position that, and particularly in light of the statute that's been argued, that there certainly appears to be some room for a analysis like that in a case like this. So, depending what Mr. Gates has to say, that's my take, Your Honor.
All right, Mr. Robertson, you can go ahead and call Mr. Gage.
Okay, I'll call Eric Gage.
All right, Mr. Gage, if you'll raise your right hand, sir. You do solemnly swear or promise or affirm testimony you give in the case pending before the courts be the truth and the whole truth and nothing but the truth, except you God.
I do.
All right, you may proceed, Mr. Robertson.
Yeah. State your name, please, sir.
Eric Gage.
And Mr. Gage, you were appointed by this court as the broker receiver to sell the 94 acres, and that's the subject of this suit. Is that right?
Correct.
Give us just a very brief summary of your business and background in real estate.
Certainly. I'm a forester. I graduated Stephen F. Austin in 1992 with a forestry degree. In 1996, I got my first real estate license, which was for Texas. I specialize in selling rural land, timberland, hunting land, that sort of thing. I'm licensed in 4 states: Texas, Louisiana, Arkansas, and Oklahoma. I've been selling timberland and rural hunting land for 25 years or more. Just 2023, I was recognized by the Realtors Land Institute as the top timberland broker in the United States. So that's my most recent thing. So stay busy.
Okay, thank you. And Mr. Gage, you listed the property for sale. Is that correct?
That is correct.
And you now have a contract from an interested buyer, and you've made a report of sale with this court. Is that right?
That is correct.
And what's the sale price for the property?
$310,000.
And that's in excess of the minimum value that you were ordered to sell for, at least $287,600. Is that correct?
That's correct.
And so this would be $27,000 more than that. Is that right?
That's correct.
And per acre, that's like well over $3,000 per acre. Correct?
Yes, sir. Yes, sir.
In your professional opinion, is this sales price and the terms of the contract, are they commercially reasonable?
It is. That's a good price.
I think you have pointed out to me before some of the problems with the marketability for this particular tract and the problems with setting the market value. Is that right?
Yes. There are some
And
issues.
would you just summarize some of those problems there?
Sure. The one issue is that about 50%, somewhere between 40 and 50% of the property lies within the floodplain. And so that's always an issue. It limits the use of the property to 50% of it to basically hunting for that area. The property is very rural. It's out in an area that's not developed, a lot of pasture land, timberland around it. The access is via an old county road. We had to get some clarification from the county, but the county did acknowledge it is a county road, but it is not being maintained. The county road ends at the property, kind of hits the middle of the property. So you have about 25, the road is only about 25 foot wide there. So you have 25 feet of road frontage for the entire property. Utilities are right about a half a mile away. So bringing power and water in is going to be very expensive. Other than that, the property had some just aesthetics. It hadn't been mowed in a while. Some of the roads had washed in the recent rains we had during the early part of the year. And so getting around on it was a little bit of a challenge. I think those were the primary ones.
Okay. You've heard the comments made so far about the feasibility of partitioning just, I think, 7/10 of an acre to some of the defendants. Do I understand from your testimony that different portions of the property have different value due to the terrain?
Yes, exactly. Because so much of the property is in the floodplain, and the highest point on the property is right there where the county road hits the property. So, that's the most, what you would say would be the most desirable area, would be right there where the road comes in if somebody wanted to eventually build a cabin or a house or anything like that. It's the most, or even a campsite, it's the most usable part of the property. From there, it kind of rolls and drops down towards the bottoms.
So if we set aside 7/10 of an acre, it would have to have its own access in order to be in order to use it, correct?
Correct. Yeah. Yeah. So I don't see any way to take out 7/10 of an acre without having some sort of shared agreement on access once you get on the property, because it's just not enough road frontage to give each owner their own access.
And 7/10 of an acre on one side of this tract might be materially different from 7/10 of an acre on another side. Is that right?
Absolutely. Absolutely. Yeah. There's not, it would be very hard to come up with 7/10 of an acre that was equal in the amount of, floodplain or highland, usable property as the entire property as a whole.
Now, the contract that you've reported to the court here, it covers the entire 94.042 acres, correct?
That is correct.
So if you're no longer authorized to sell 94 acres, this contract would have to be revised or voided and a new contract entered into for 94 acres less 7/10 of an acre, right?
That is correct. And then my other concern would be, would the buyer actually still be interested? As I mentioned, this is a very rural property. It's the biggest attraction to most buyers is the seclusion out there. You don't have neighbors. The tracts around it are large properties, so you're unlikely to get people building right up against the property line, or having to share a road and that sort of thing. Nobody uses that road. That's why it's not being maintained to any degree. Some of the other neighbors are using it to get in their back pasture, but that's nothing significant. And so if you end up with carving that piece out, you take away that seclusion, because now you all of a sudden have a neighbor that you have to share a common gate with, fence with, road with, that sort of thing. So this buyer wants to use it for hunting and put a cabin on it, it would be less interested. And I fear I would lose the contract.
So in the event you had to void this contract and then negotiate a new contract with this same buyer, do you know whether in fact he would be willing to pay the same price for the tract with the reduced acreage?
I do not know for a fact one way or another. I haven't brought that up with him.
But you think it may be possible that he would want to a
If
sales
I were-
price a little less?
If I were to put myself in his shoes, I would want to, if I was still interested, I would negotiate a lower price because I'm losing some of that benefit.
And if that's the case, then the value of the property as a whole would be less if the property is not sold as a whole, as one tract. Is that right?
I would agree with that. I think what I'm trying to say is that the discount to the property as a whole would be significantly more than just subtracting 7/10 of an acre at $3,300 an acre, I think is our price. So it would, say for sake of argument, that's $3,000. The value of the property would decrease by significantly more than $3,000 by having that little bit of the new neighbor put in right there at the gate.
Okay, the value of the entire 93 acres, correct?
Correct.
Okay, I'll pass the witness.
Mr. Hughey?
Mr. Gates, I first respect you for being so honest, but the fact of the matter is you don't know what impact it will have until you talk to the potential buyer. Is that correct?
That is correct. I have not broached this with the buyer.
So all the comments about not wanting the neighbor, et cetera, is just your speculation, your thought process.
Not entirely. I mean, it's also based on my showing the property to the neighbor and what attracted him to the property.
Okay.
My discussions with him.
And is your testimony that a 0.0035 deduction out of a 94-acre tract is a significant game changer, deal killer? Is that what your testimony is?
It is only because of the way the property is set up and how remote it is.
Okay.
If this was out on a public road, where there's more road frontage, you wouldn't be taking away road frontage, or you wouldn't have to be dealing with a sharing road. It wouldn't be an issue, as much of an issue.
So your issue is sharing a road?
When you get into these rural properties, that is a big issue. Yes, is who maintains the road, who's allowed to use that road. When you come in on a property like this, you don't expect to have to run into people. For example, on opening morning of hunting season, all of a sudden somebody parks in the middle of the road. It happens all the time on shared roads. I hear about it constantly from other clients and the properties that are managed out of this office. So it causes problems because you have more people you have to deal with.
Now, you're talking about your client and not my client.
No, I don't have any experience with your client. I'm just saying that's what happens when you share a road.
Okay. But you can't share a road.
It happens all the time. It just, yes.
And you can share maintenance on the road.
You can.
Okay. I pass the witness, Your Honor.
Mr. Wilder?
Mr. Gage, the road that you're talking about, did you tell us that was a county road?
Yes. County road dead ends at the property.
So the road that you're talking about is actually a public road.
No, what I'm saying is because there's no road frontage except for the gate, the 25 foot is if you were to parcel out a property, you would have to have to go in from the county road into the property to get to either section if you divide it out. Because there's no way to divide just 25 feet of road frontage where road owner A has access and owner B has access and they're not combined.
Okay, but you're not saying that the access into the property is private, are you?
No,
And that is a public road from, I guess, from some highway into this property that can be shared by any member of the public.
to the best of our knowledge, yes, that's what the county has acknowledged, that that is a public road.
Okay.
I don't have it surveyed, so I can't say it touches exactly right to the property, but that appears to be the case.
Thank you, Mr. Gage. I'll pass the witness, Your Honor.
All right. Judge Dean, do you have any questions or comments? All right. Judge Dean, you're muted
How's that?
now. Okay, yes.
Okay. Yes, Mr. Gage, seven, what's the percentage that they own in the track again? Somebody said point something.
Yeah, it's 0.00757576.
0074.
Yeah, 0075.
I don't have my calculator, but I think I had calculated that earlier. And is anybody, if you take a strip, let me ask you this, Mr. Gage. Normally, when I've seen these tracks partitioned, they're kind of done in strips. So that they take into account all the factors that you've talked about, that you get a little high land, you get a little low land, you get a little in the middle. Of course, there's always improvements, and like in this property, there's a pipeline across a portion of it. So if you were clear of any obstructions and it was all even, I think I calculated something a little over a 10-foot strip that you'd take through this piece of property from front to back. Have you looked into what kind of strip size this would be?
I did not. I thought about, just a square because that made the most sense to me instead of a strip, as far as if I was on the other side and wanted a piece of this. So I didn't even think about a 10-foot wide strip down the fence line.
So you wouldn't take a 0.00745, you'd take something less than that if it was on frontage up high, and that would require some kind of valuation involving realtors to determine what's a fair amount. Is that right?
Or as I understand it, commissioners, but yes, that would be correct.
Commissioner's right. Now, you've participated, I assume, in your history in some petition suits. How have you ever seen one of this small tract partitioned out that was situated like this property?
No, sir. No, I mean, I think the smallest I've seen is about 4 or 5 acres.
Okay. And my understanding is that wherever you place this, if it's not just right up on this access, 25-foot access into the property, you're going to have to do an access easement. What's normally the width of an access easement?
Normally, you need to have 40 feet just because if you're going to bring in heavy equipment in the future, log trucks, equipment to bring a house, in a house, they need to have 40 feet of width.
And I don't mean to get too legal on you here, but my mind goes in legal areas is the people that are selling more or less, or the new owner would be a dominant track, and then the servitude track, and the dominant track would be this 10-foot strip or square of whatever that is in acreage. I don't guess you figured how much acreage that would be out of 94, have you?
Somebody told me 7 acre. I haven't
Okay.
done the math.
Well, that's what I had figured. I must have heard the same thing on that 10-foot strip. But so the access is going to be wider than the strip, or take up more property, I should say, if it's off out of the way from the entrance. Is that right?
Correct. And And I would say even at the entrance, because you have to have enough room to bring a vehicle in, so you're going to have to do something to combine
All
either
those
reciprocal easements. Yes.
all those factors of the servitude track that they have to put up with, including trying to secure the entrance to this property with locks and gates and how that's going to all operate. Would, in your opinion, all of that, plus the things that you've standardly seen with accesses, affect the market value of this tract of land if sold as a whole as opposed to divided up? Would it depreciate the marketability?
Yeah.
What was your answer?
I think you closed out there at the end of from what I
Okay,
said.
I'm sorry. If a 40-foot access is taken to go to wherever this track may be, which quite frankly, for the record, I know I'm partly representing myself on this, but I haven't been contacted about any offers to where they'd be located. But wherever it is, that's going to affect the value of the remainder of the tract, is it not?
That is correct. Yes.
And of course, it'd take somebody beyond your skill to estimate what that value effect would be. And
Sure.
maybe
Okay.
draw this thing out even longer. Is that right?
Right.
I guess I'm just concerned. I want to make sure it's clear for the record that in the law, and I'm sure all these good lawyers that are on the phone with me are familiar with the rule of alienation of property that has to do with not placing restrictions and servitudes on tracts that
Judge-
school.
Judge Dean, you're in and out.
Cutting out? Okay, I'll get a little closer here. Is it a small, in this case, my question is this, get a small interest that's being set out to protect, I guess, the small interest owner, create an onerous and burden on the other interest and on the uses of the property by the future owner? Did you hear that? I guess I cut out again.
Yes. Heard that. Was that a question for me?
Yes, yes, sir. Was that a question? Is all of that gonna affect the marketability of not only this track, but maybe even the dominant track at some point?
If I'm understanding you correctly, I would say it does affect the buyer's mentality on a track and what he's willing to offer when he has to. Anytime you add additional neighbors issues, such as servitude and dominance of property rights on easements and that sort of thing, it definitely has an effect.
Okay. And I just in concluding, I know didn't say much in the beginning, but just ask the court. I refer to the court my election of sale that I filed with court. The court's probably reviewed that as far as taking in the factors that the court's to consider, certainly the ones that have been mentioned by Mr. Hughey and his clients are in there, but there are other interests and uses and I think it's clear that the marketability is definitely going to be affected not only today, but tomorrow. That's all I have. I'll pass the witness.
All right, thank you. All right, gentlemen, I'm reviewing all this. I'm going to deny the motion to reconsider, and I will grant the request to approve the report of sale.
Okay. When I get you an order on a denial.
Yeah, both sides give me an order on their respective motions.
Okay. Thank you, Your Honor.
Thank you, gentlemen.
Okay, thank you.
All right. Thank you, gentlemen. Sorry, I was cutting in and out.
No problem, Judge.
Judge, may I be heard just a second, and it may be to come, but who is to account for my fee in this matter?
It'll be accounted for and withheld from the sale in a proportionate manner. Have you discussed or filed a bill with anyone?
I have not, Judge. I didn't.
All right, if you'll file a bill with the court and send it to the to the, parties who are involved, and then it'll be, paid in proportionate with their interest as set forth in how the sale. Am I clear? Do y'all understand what I'm saying?
Yes, Your Honor.
You just want me to send the bill to all the parties, Your Honor, and
And to the court. So I mean, just for the file, for the purpose of the file, and the parties then will pay in their proportionate interest.
okay.
All right.
Thank you, Judge.
As cost to court. All right. All right. We'll stand in recess in this matter.